So, in this lecture, I'm going to discuss the concept of performativity, um, which was made extremely popular by Judith Butler, whose writing looks at the ways that gender is performative. So, rather than being innate or natural, what Butler argues is that gender is performative. And Judith Butler draws on J.L. Austin's ri- uh, writings, How to Do Things with Words. And what Butler argues is that gender is not something that we describe, it is something that we enact. So, drawing on Austin, what interests Butler is how people do things with words. So, when a child is born, a doctor will declare it's a girl or it's a boy. When people get married, the person who is marrying them will say, with this ring, I thee wed. And so words do not just reflect reality, words um, lead to an enactment of performatives under signs. So if I'm called a certain name, a girl or a boy, a woman or a man, I enact a set of rituals, a set of iterative utterances and performatives over the course of my life to perform under this sign. And performativity is not performance, so it shouldn't be equated with or thought about in relation to a performance that we give that ends. Performatives involve our speech acts, our tones of speech, the ways that we use words, even how big we open our mouths when we speak. Could be about gender identity. It could be about cultural or national identity. The ways that we sit, so if someone sits with their legs spread or legs crossed, are performatives. And we learn how to enact these performatives over the course of our lives. What interests Butler, however, is thinking about the constructed nature of these performatives. So if these performatives begin with these binary declarations, it's a girl or it's a boy, then could they be undone or could they be um, challenged or uh, even critiqued by gender transgressive actors? And Butler's work has become extremely popular in thinking about queer theory and transgender theory. So, if gender is constructed, then can I undo the work of gender, or can I challenge this work of gender by enacting a different set of performatives? If I do this, what are the costs? What are the socio-legal frameworks, the societal frameworks that are in place that will uh, discipline me or punish me if I try to enact a different set of performatives rather than these normative scripts? So I'll share my screen and I will post the slides online and we'll discuss Judith Butler's work in detail for this section of the class. So, Judith Butler's work has not only touched on gender and gender performatives as speech acts. Butler is also interested in hate speech and the ways that hate speech also determines identity construction. So, in looking at the burning of crosses in an essay about hate speech, Judith Butler argues that rather than being an individual person who performs under their own will, or rather than being an individual person who just speaks in accordance with their own agency or will, we all speak because of a history of a community of speakers. So, in instances where people burn crosses as an act of hate speech and specifically anti-Black racism in the United States of America, Butler argues that these speech acts cannot be thought of as just individual utterances. They must be thought of in relation to a history of a community of speakers whom we draw upon to make meaningful signs in the world. So, if we were to think about the ways that we enact gender in certain societies, the way that we appear in public, the ways that we look, the ways that we speak, obviously draw upon a community of speakers. So the research that I have done as a postdoctoral uh, researcher and as a PhD student has looked at gender and sexuality, feminism, and queer rights in India. So the way that people enact performatives of gender in India obviously is very different than in Canada or in any other country. Um, People draw upon a series of signs, signifiers, words, um, forms of adornment to appear as a gendered subject in public space. So even the wearing of religious signifiers, wearing a bindi, for example, connotes a certain gendered religious subjectivity. In order to understand what these signs mean, we have to be familiar with a whole history of a community of speakers, a history of India, a history of colonialism, Gandhiism, religious sects and groups of people. Uh, this is also true of acts of hate speech. And so Judith Butler is one of the most well-cited theorists of our time. And in this lecture, I will try to use Judith Butler's work about gender performativity and Judith Butler's writings about the burning of crosses to discuss the relationship between gender performativity, rape culture, rape law, and sexual violence. So, performativity for Butler is the power of language to effect change in the world. Language does not simply describe the world, but may instead or also function as a form of social action. For Austin, performative language included speech acts such as promising, swearing, betting, and performing a marriage ceremony. So, promising or swearing or betting is not just the use of language as a form of description or a form of repetition, which does not lead to action. Language precedes action and it determines actions. It also determines social relationships and it determines contracts. So, the language of gender performatives in the marriage ceremony then determines the marriage contract, which is a legal contract. Performativity of gender is a stylized repetition of acts, and imitation or miming of the dominant conventions of gender. Butler argues that, quote, the act that one does, the act that one performs, is, in a sense, an act that's been going on before one arrived at the scene. So before one arrives at the scene of marriage, there are all of these performatives that enact a marriage. And there are also laws, obviously, so that if you are married and you are legally married, it is not just words. You are not just called a married couple. There are a whole set of legal injunctions and social contracts that you must abide by in terms of sharing of money, in terms of respect for your spouse, the grounds for divorce could be committing acts of infidelity without your spouse's knowledge or consent, using your spouse's income or your family income for your own financial purposes. Um, Also, if you live in a household with your spouse, part of, say, a marital contract or part of the grounds for divorce is if you were to disrupt your marital home and make it impossible for your spouse to live there or do work there. And so the language, these performative speech acts, like performing a marriage ceremony, have real life consequences. And the act that one does, obviously, is not just an act of free will without context. If you perform gender in a certain way, you arrive at the scene of gender, and it's been going on long before you arrived. And so, in certain contexts, say in certain states, in the United States of America, transgender rights do not exist, or they're not upheld in the law. And so if you arrive at this scene as someone who is transgender or non-binary, then your individual acts, your individual performance in public space, how you self-present as a gendered subject, will already be something that is not recognized by people who know you, but is recognized by a history of a community of speakers. This is also true of race and racism. So if you were to go to certain countries where there is a long history of slavery, lynching, police murders of Black people and other people of color, you will arrive at this scene and it will already be set for you. So, irrespective of your self-identification, your self-esteem, your own personal history, a history of a community of speakers has determined the legal context and the societal context in which you enter into relationships. If a word in this sense might be said to do a thing, then it appears that the word not only signifies a thing, but that this signification will also be an enactment of the thing. It seems here that the meaning of a performative act is to be found in this apparent coincidence of signifying and enacting. So, signs and signifiers are written about by scholars of semiotics. And Judith Butler's work is really exciting because it crosses so many disciplinary boundaries. Judith Butler draws on theories of language and semiotics. Butler also draws on the law and histories of the law to look at the ways that there are injunctions against certain um, social actors who defy normative acts of performance or performatives, or whose acts of signification do not correspond with the dominant law and society in which they live. Butler's work obviously also draws on queer and feminist theory to trouble previous understandings of gender as being innate. So a word is a sign, and I use it to signify something. So in English, if I said water, uh, I would say the word water. I would also say points, say to a bottle of water. And it would be the English language word water and a bottle of water that people can recognize in the context of Canada. If I was in another context, I would say a different word for water, and it could be water from a well. And so the sign system that we use must make sense to us as a community of speakers, or we cannot understand each other. The way that this becomes political in terms of gender is our understanding of what it means to be a woman or what it means to be a man. So, if someone, for example, understands that a woman is someone who can work for a living, a woman is someone who could be a lesbian. A woman could be non-binary and become a trans person or a non-binary person. So our understanding then of this shared sign system breaks down when we do not understand these terms to be the same. So race is a good example. And Butler's writing about hate speech and the burning of crosses is a really popular essay, and it's a really interesting and somewhat sad essay about the history of lynching and racism in the United States of America. So, when we think about people of color or we think about certain ethnic groups, our shared understanding, our shared system of signification breaks down if we have different ideas of what different people can do because of their ethnicity. Religion is a good example. So, if certain people practice an orthodox religion that prevents women from working outside of the home, from getting a divorce, from being lesbians, or from being non-binary or transgender or queer or bisexual, then our shared meaning will break down. And we can see instances of how this meaning breaks down in terms of the law. So, if one group of people believes that women, as a group of people, cannot work outside the home, cannot make money, cannot spend money, cannot have sexual intercourse with whom they choose to, um, cannot be lesbians, cannot wear what they want, then this group of people has the legal right to be a self-functioning community that believes in these values. And the ways that they can signify to each other will make sense to each other. However, if they impose this system of signification upon the general population who does not believe in these norms and believes that women as a group of people can work, can be lesbians, can be bisexual, can get a divorce, can make and spend money, can do what they want with their lives, then this group of people who forms the majority could enact a whole set of laws against those who threaten their way of life. And the same could be true in a certain context if in a predominantly religious Orthodox society, I was to try to change the ways that the term women are signified by challenging, say, laws against lesbianism or religious norms against dress, I would be disciplined and I could perhaps be put in jail or removed from the society. So the title of J.L. Austin's How to Do Things with Words interests Judith Butler because Austin's work poses the question of performativity as what it means to say that things might be done with words. The problem of performativity is thus immediately bound up with a question of transitivity. What does it mean for a word not only to name, but also in some sense to perform, and in particular to perform what it names? On the one hand, it may seem that the word, for the moment, we do not know which word or which kind of word enacts what it names, where the what of what it names remains distinct from the name itself and the performance of the what of that what. After all, Austin's title queries how to do things with words, suggesting that words are instrumentalized in getting things done. Austin, of course, distinguishes between illocutionary and perlocutionary acts of speech, between actions that are performed by virtue of words and those that are performed as a consequence of words. So we can think about how gender operates. Does gender operate by virtue of words or as a consequence of words? So, by virtue of words, one might be declared to be a girl or a boy at birth. But as a consequence of those words, does one have to perform under these binary terms throughout the course of their lives? The answer is, of course, no. And this distinction between the illocutionary and the perlocutionary is where gender moves from being something that exists by virtue of words to being something that is a consequence of words and that can be undone with other consequences. And the other consequences could be legal. Bill C-16 adds gender identity and gender expression to the Canadian Human Rights Act and the Criminal Code. So someone can legally be transgender, non-binary, questioning of their gender identity, gender transgressive, um, intersex throughout the whole course of their lives in Canada. And if one is discriminating, or if one discriminates, or an employer discriminates, or an institution, or a university, the police force, healthcare people, if we discriminate against someone because of their chosen gender identity, we can face criminal charges in Canada. If performativity requires a power to effect or enact what one names, then who will be the one with such a power, and how will such a power be thought? How might we account for the injurious word within such a framework? The word that not only names a social subject, but constructs that subject in the naming, and constructs that subject through a violating interpolation. So, if I choose to give myself a name like non binary or bisexual, and my name is violated by others. I am given another name. I am told that I am a woman, and I am told that I am a heterosexual woman, and that is all. Then who has the power to injure me? And in many ways, we can think about Judith Butler's work in relation to the last lecture about Bill C-16 of the Canadian Human Rights Code and the Criminal Code, which adds gender identity and gender expression to a group of protected categories of persons who cannot be discriminated against because of their chosen gender identity. And uh, in kind of everyday speech acts and in Canadian media, Bill C-16 are referred to as transgender rights laws, and they are comprehensive laws that protect transgender people and also non-binary people and queer people and people who question their gender identity throughout the life course. So is it the power of a one to effect such injury through the wielding of the injurious name? Or is that a power accrued through time, which is concealed at the moment that a single subject utters its injurious terms? And I return again to this community and history of speakers. So, if I draw on a community and history of speakers in Canada and Canadian law, then I would be aware that Bill C-16 adds gender identity and gender expression to the Human Rights Act and the Criminal Code. And so if I use these injurious terms, if I refuse to use someone's proper gender pronouns, their chosen gender pronouns, they and them, I can be corrected. And this act of correcting can be as simple as asking someone to please use these proper gender pronouns. So I can be asked to use these gender pronouns. As a speaker, as a writer, as uh, an employee in Canada, I can also choose to avoid gender pronouns by using the person's proper name. So I could use the term or the name Judith Butler or Jade Butler. Uh, I could also be asked to issue an apology because of my lack of use of these proper terms. If I consistently choose to use injurious names or words against someone, I can then be disciplined using the Canadian law. So this is a clip of Judith Butler. I'll actually play another clip, which I think is better, which is more recent. Sorry, bear with me for a second. For some reason, I'll come back to the clips as we go on. Sorry about this. Judith Butler's work has been cited so frequently, and there are a lot of really interesting films and interviews with Dr. Judith Butler. Okay, so this is the clip that I wanted to play. Any apologies, I'll share my screen. And it is a recent clip of Judith Butler discussing gender theory. And Butler's work, as I mentioned, has a lot of other interesting elements. And if you're interested in writing about Judith Butler for your essay or doing a presentation about Butler's work, you could also look at Butler's other writings about hate speech and also about nonviolence. Judith Butler has written a book called The Force of Nonviolence, in which Butler discusses the importance of nonviolence. And Butler draws on uh, Gandhi and other philosophers to look at the importance of nonviolence as a, a moral and philosophical principle in all forms of conflict. And so you might be interested in thinking about this for your presentation and for your final assignment as well. If you're interested also in law school, you might want to look at Judith Butler's work. A lot of Butler's work regarding language is really interesting for law students. And I've had several students who have gone on to law school and who have used Judith Butler's writings in their law school application and have done very well because the law is really about language. And as we discussed in the previous lecture regarding Bill C-16, language is not just neutral. Language is also not something that does not injure others or does not have an effect on someone's career, on someone's life choices. At the same time, language is also not something that can be programmed in human beings. So people speak and they speak freely and they don't necessarily plan every word they say. Sometimes people stutter or stammer, and so obviously language cannot be policed. And this is why it's really interesting for someone who is interested in the law or social justice, human rights, to think about the relationship between human rights and language. Language is also, as I've discussed in previous lectures, about class. And so if you do not have access to a certain language, you are not aware of say certain English language terms or the kind of legal or political meaning behind using terms, uh, say like girl or uh, boy, if you don't necessarily know about these histories of law and social movement activism and lobby groups, then can you be held accountable if you are unaware of what certain terms mean? Uh, Language regarding race is really interesting to think about from the perspective of class, that terms like people of color, women of color, queer people of color are English language terms that are popular, and they're often popular in a certain sect of, say, professional labor. So even the use of gender pronouns at the end of someone's professional email is common. But is this true of someone who does not work in a professional industry? If someone has not had the benefit of a university education, will they be discriminated against because of their use of, say, colloquial or slang terms? So these are interesting issues to consider when we think about Judith Butler's work.
This is my 100th fire. Okay. Got
So there are many different theories of gender, and mine is just one. Sometimes people who really hate gender name me as the one who made this up, but that's actually not true. You know, in my view, everybody has a theory of gender. And what I mean by that is that everybody has certain assumptions going about what gender is or should be. And at a certain point in life, we ask ourselves, wow, where did that assumption come from? At this point, I'm less concerned about whose theory is right and whose theory is wrong, because the assault on gender is also an assault on democracy. We have the power and the freedom to make more livable lives for ourselves, where bodies can be more free to breathe, to move, to love without discrimination and without fear of violence. I am Judith Butler, Distinguished Professor in the Graduate School at the University of California at Berkeley. I teach literature, philosophy, and critical theory, and I'm most well known for my two books on gender, Gender Trouble and Bodies That Matter from the early 1990s. My work has been translated into more than 27 languages. I insist that what it is to be a woman, or indeed what it is to be a man or any other gender, is an open-ended question. We have a whole range of differences, biological in nature, so I don't deny them. But I don't think they determine who we are in some sort of final way. At the heart of these controversies is the distinction between sex and gender. But what is that distinction? How do we think about it? Sex is generally a category that is assigned to infants that has importance within medical and legal worlds. Gender is a mix of cultural norms, historical formations, family influence, psychic realities, desires and wishes, and we have a say in that. My early life was affected by the 1960s and the social movements that took shape during that time. I grew up on the east side of Cleveland, part of a Jewish community. And by the time I was in high school, I was politically active, but I was also taking university courses in philosophy. In my 20s, I came to see that it was not just the Jews who were apprehended and extinguished by the Nazi regime. It was queer people, it was gay, lesbian people, it was people with disabilities, people with illnesses, Polish workers, communists. And my sense was that one needed to widen the lens and see that many people have been subject to genocidal politics and to understand that there are different forms of oppression. I remain convinced that one does need to know history in order to make sure it does not repeat, and that one wants justice not just for the group to which one belongs, but for any group that suffers in a similar way. In the 70s and 80s, I was part of a movement of people who were rethinking gender during that time. Queer theory was emerging. It was in a complicated conversation with feminism. Trans issues had not yet surfaced as part of our contemporary reality. So it was a moment in which we asked questions like, what has society made of us and what can we make of ourselves? There were a number of versions of feminism that I tended to oppose. One of them held that, well, women are fundamentally mothers and that maternity is the essence of the feminine. And then a second one thought that feminism was about sexual difference, but the way they defined sexual difference was always presumptively heterosexual. And both of them struck me as wrong. I was pretty committed to the idea that people ought not to be discriminated against on the basis of what they do with their body, if they, who they love or how they move or how they look. All I was saying is that the sex you're assigned at birth and the gender that you are taught to be should not determine how you live your life.
Staying late again? Yep, got prospect calls to summarize. You really need to switch to Monday CRM. Go.
Sometimes people point to gender trouble as the inception of gender theory, but people were working on gender before me, Gail Rubin and Juliet Mitchell and Simone de Beauvoir herself. Simone de Beauvoir was an existential philosopher and a feminist philosopher who wrote The Second Sex in the 1940s. The basic point was that one is not born a woman, but rather becomes one, that the body is not a fact. She opened up the possibility of a difference between the sex you're assigned and the sex you become. Gail Rubin was an anthropologist and remains an anthropologist who wrote an extremely influential article called The Traffic in Women. And what she tried to say was that the family was a structure whose task it was to reproduce gender. And one of the aims it had was to kind of keep heterosexuality looking really normal. And although it was part of feminist anthropology at the time, it allowed us to start thinking about gender as something that could be reproduced, crafted, cultivated, and that there were systems, frameworks to which gender belongs. There was one other dimension of Rubin's work, which was, interestingly, psychoanalysis. She basically said, well, maybe there's a whole lot of repression going into becoming a man and a whole lot of repression going into becoming a woman. And that one of the things we have to do is to conform with existing gender norms, is to rule out all those possibilities of being, feeling, doing, loving that don't line up with the gender norms that are governing our lives. So anthropology, psychoanalysis, they all had their place in that moment way before gender trouble emerged on the scene. I think at the time that I wrote Gender Trouble, people treated gender as if it was a natural fact or a sociological reality, but they didn't treat it as something that you could make and remake. Performance is important to the extent that we do enact who we are. And anybody in performance studies actually knows that there are performances that we do in our lives that are not mere performance, they're not fake. When performative was first coined as a word, the philosopher J.L. Austin, was trying to understand legal utterances. So when a judge says, I declare you man and wife, you become man and wife once that declaration has happened. That's not fake. That happened. Now, what if we were to say that in enacting our lives as a particular gender, we are actually realizing that gender anew. We are making something real happen. When gay and lesbian people started coming out, or when trans people started living openly, something changed in the world by appearing, speaking, acting in certain ways. Reality changed, and it has changed. We are seeing the changing of terms. We no longer speak about family, woman, man, desire, sex in the same way. Even the Cambridge Dictionary acknowledges that something has changed. Okay, so when we talk about performative, we're talking about an act that makes something come into being or an act that has real consequences. We're talking about the changing of reality. Even among progressive and liberal people I know, there can sometimes be a real resistance to thinking about trans rights or lesbian and gay rights or even women's rights. They sometimes say that these are secondary issues, or it simply makes them uncomfortable. Why should I have to refer to someone as a he or a she or a they? And yet, at least in the US, we learned how to talk about Black people differently, or we talk about women differently. And sure, it was probably hard to learn how to use new language. Maybe we had to adjust our habits, but stumbling is part of learning, and making an error is part of learning, especially when we're learning something new. Sometimes we can all be vitriolic, right? Some certain statements will set me off and I will scream. But if I only were to do that, then I would never be having a conversation with anyone. I think we all want to be the moral center of our universe. Like, that's right, that's wrong. You're canceled, you're not. You're with me, you're against me. But we have to allow ourselves to be challenged and accept the invitation to revise our ways of thinking, because that's the only way of being open to people who are trying to make their claim, sometimes for the very first time, to be heard, to be known, to be acknowledged.
Losing track of money spent on acquiring customers? With the Zoho expense and Zoho CRM integration, start quantifying your.
Now I'm less interested in defending a theory of gender. I'm much more concerned with finding creative and effective ways of countering the attack on gender. One problem is that many people who refuse to allow trans people to define themselves is that they feel that their own self-definition is destabilized. The idea that we can change reality, transform reality to be more open, inclusive, just, less violent. There's an instability in that that's very frightening to people who want to understand their genders as fixed. But is anybody's gender necessary and universal, or is it a complicated emergence that happens with each of us? Our deepest sense of self is also formed in time, and we can't always know in advance what that will be. Freedom is a struggle because there's so much in our world that's telling us not to be free with our bodies. And if we are seeking to love in a free way, to live and move in a free way, we actually have to struggle to claim that freedom. When we live in a democracy, we assume that we're living according to certain principles: equality, freedom, justice. And yet we're constantly learning what freedom is and what equality is and what justice can be. And those challenges, right? The anti-slavery movement, the suffrage movement, the movement for LGBTQIA plus rights. I mean, each of those struggles involve challenging people's existing ideas of who's equal, who has the right to be free, And how do we define justice? We are all the time struggling to achieve that goal. We need to reoccupy these notions and show that concerns with racial justice and gender equality and gender freedom are an integral part of any democratic struggle, especially if we want to rethink who the people are and what it means for them to live in freedom without fear.
Let's just wrap up the gender stuffs. Unless you want to take a break from gender, we can go back to that. Do you want to let me give you the prompt for the last few
My
minutes?
whole life I've wanted to take a break from gender. I can never take a break from gender.
Get smarter, faster with videos from the world's biggest thinkers. To learn even more from the world's biggest thinkers, get Big Think Plus for your business.
So we'll go back to the lecture slides. And throughout the lecture, I want to think about Butler's work theoretically, but I also want to think about the political consequences of Judith Butler's work, particularly in this time period. So we'll discuss the banning of abortion in several states throughout the United States of America as the class goes on. So Canada is in a very specific position in terms of our laws protecting the rights of people to have an abortion and protecting transgender rights. But obviously, there have been a lot of threats to personal freedom and to the rights of women and trans and queer people in the United States of America in the last few years. So Judith Butler's work then is not only theoretically interesting, it is politically important. And as I mentioned in this essay, Burning Acts, Injurious Speech, Judith Butler discusses the burning of crosses. And the question Judith Butler asks then is also interesting in thinking about Bill C-16, which adds gender identity and gender expression to the Human Rights Act and the Criminal Code. And this is really the question that Butler wants to pose in this essay about injurious speech. Who or what should be held accountable, if at all, for injurious speech? In Judith Butler's Burning Acts, Injurious Speech, she explains that while we think that we are subjects who are responsible for everything we say, in actuality, a community and a history of speakers is magically invoked at the moment in which the utterance is spoken. In other words, we are not the origin of our thoughts and feelings and utterances. Every time we think we speak our own words, the framework and lineage that actually produces those words is hidden. Thus, when it comes to injurious utterances, Butler is concerned with the following. If the utterance is to be prosecuted, where and when would that prosecution begin? And where and when would it end? So, for example, if you learned to use a series of terms from your parents or your grandparents that are gendered in nature or that are racial or a certain language regarding identity from your parents or grandparents, you can be held accountable, I guess, as an adult in the eyes of the law. But at what point are you held responsible? So, at what point must you take responsibility? And the law is clear in this instance. And I would say, as someone who lives in Canada and understands Canadian laws, that once you are an adult who is working, even if you reach the age of, say, 16, you can work in Canada. And once you enter into this labor contract, you are entering into a whole series of relationships that involve showing respect to the general public and familiarizing yourself with the law. And you obviously wouldn't be fired from your job if you consistently didn't use someone's gender pronoun properly, but you would be asked. You wouldn't be fired right away. You would be asked and you would be told politely, and you can just say sorry and then correct your behavior. But if you consistently refuse to change your acts of speech, whether it is about, say, people of color or whether it's about using the pronoun she, her for someone whose pronouns are actually they, them. if you consistently refuse to change your speech, you can be disciplined. And you can be disciplined in Canada because of the law and the laws of, say, the Human Rights Act and the Criminal Code are also about business. So an employer would have to, I guess, pay money to the city of Toronto or the province of Ontario or to the government of Canada to employ someone who consistently refuses to follow the Canadian law. So, like any other set of acts and codes that protect the public and that institute a set of norms that protect the public as a group of people that are all thought to be the Canadian public, one has to uphold these norms. So, for example, if you want to sell meat or beef or alcohol in Canada, yes, you can. And if someone does not want to buy these things, we cannot force them to buy these things. And so the point is that the public has to be considered to be a general group of people whom secular laws can be applied to. And so the pronouns, using someone's proper gender pronouns, are similar. If you do not want to have a relationship with someone, because their pronouns are they, them. You do not have to. If you don't want to buy something in at a business or you don't want to go to a certain neighborhood because they have employed non-binary or transgender people, you cannot be forced to do this. You can stay home. You can avoid taking university classes in gender studies. But if you enter into these relationships, which are contractual relationships, then you must abide by the laws that govern these spaces and places, which are secular Canadian laws. So again, Butler asks, can we prosecute history, institutions? Where do we draw a line, if at all, between personal responsibility and inherited structures of feeling and citations? How can we prosecute individuals when dominant orders, example, the Supreme Court, systemically sanction certain kinds of injurious speech and behavior? And this is specifically for Judith Butler about the burning of crosses in the United States of America and the amendments of free speech that protect people and uphold someone's right to, say, burn a cross or a flag. But Canada is different in the sense that we have the right to free speech, yes. But if your acts of speech are going to injure someone and are going to injure a protected person, such as a person of color, a religious minority, a transgender or non-binary person, then the law can be used against you. So your acts of free speech could exist as, say, someone who is a YouTuber or an author, a public speaker, and you can speak in general terms. So if you have a critique, say, of I guess, white nationalists, then yes, you can then make a video saying, I am critical of white nationalism. I think that it propagates hatred and it will lead to discrimination and hate speech, and it will do significant damage to the population in North America. I can make these claims in general terms. If, for example, I find someone who is white and I believe to be a white nationalist and I start to harass them, if I start to write about them on the internet, if I try to get them fired from their job, then this is discrimination of a specific person. And people obviously have the right to identify as a right-wing Republican Christian if they want to. And this is a good example. A more kind of clear example and less obscure is abortion. So I have the right in Canada to have an abortion. I have the right tell people that they can have an abortion. This is the law, but I cannot actually force someone to believe in abortion. I cannot harass or discriminate against someone who does not believe that abortion is morally right. And because of their religious beliefs, people might believe that abortion is wrong. And so, yes, I have the right to then make generalizable statements. I have the right to publish scholarly articles supporting my beliefs. I do not have the right to actively discriminate against someone who has strong religious beliefs and who does believe that abortion is not moral or religiously sound. And obviously, there are many different strains of philosophy. Theology is a really a strong aspect of philosophy throughout the world. And many theologians might believe that abortion is immoral. And so, as academics, we can debate. But if we start to attack each other personally or ruin each other's capacity to do business or ruin each other's capacity to, say, live in a certain space, then this would involve the law. And so I believe that people can be held personally responsible for injurious speech, injurious words or speech when it involves injury that is done to a person or group of people that could be detrimental to their economic future, to their capacity to make money, to their capacity to live productive, healthy, peaceful lives. And so, if someone has such strong views, say, against people of color, then their views could be detrimental to people of color in general, and they could be hurtful. So, if someone immigrates to Canada from South Asia or from a country in the global south, if they meet with or if they are exposed to people who are really racist, they might be afraid and they might leave Canada. So this is not only detrimental to these people who are people of color or who are people who are immigrants from countries in the global south, it is detrimental to the Canadian economy. And so individual responsibility is also about, I think, the individual harm that one could do as a speaker, as a writer, as an actor, uh, as a person whose views are so strong that they could do damage to the economy. So Judith Butler investigates the U.S. Supreme Court case of REV versus St. Paul, in which a young white man burned a cross on the front lawn of a black family's home. She uses various philosophers and theories to present the difficulty of the case based on the U.S. Supreme Court's decision. The Supreme Court did not condone the actions, nor did it suggest the actions were acceptable. However, it was a case where the evidence did not prove the act to be injurious to the family and fell under freedom of speech guaranteed by the First Amendment of the Constitution. Butler also presents various theories on the performativity of words and actions. Performative words communicate an effect, create an emotional response, and are used to affect someone either positively or negatively. They include injurious actions and hate speech. So, if we were to think about this from the perspective of the law, I would argue that the burning of a cross in a video that an artist makes, or the burning of a cross in a painting, is not the same as the burning of a cross on someone's lawn. So I would turn to property laws. And Canada is really a clear, Canadian laws are really clear about this. So if someone does not like me or does not like my imagined ethnic group, or my parents are from India, and so if someone does not like this fact and they don't like people who are part of the Indian diaspora, they can make videos and they can state their case in video format. They can write what they want. But if they threaten my property, this would be dealt with using a whole other set of laws regarding the rights of property owners. And so this is clear in the law. The problem, of course, is the application of the law. Someone would have to use laws against those who threaten their property. Um, Again, this is about the economy. So if someone burned a cross, outside of a home I own, then I, as a homeowner, could sell my home and I could move somewhere else in Europe. And if everyone was capable of doing this, then people who do not own homes could just attack homeowners. And this could be a way that class antagonism is expressed. And those who are, say, unemployed or without property could drive homeowners out of a city or out of a country as a form of protest against middle class property owners. So Judith Butler investigates the linguistic aspects of censoring homosexuality and homosexual acts. She suggests that the US military created an atmosphere of paranoia around the regulations of homosexual speech and acts because they were considered taboo by and for those in service. The military viewed homosexuality and homosexual acts as both disruptive and contagious. Butler also argues that the regulations hindered those who identified as homosexual because they could no longer identify with who they were and were required to pretend they were not gay in order to serve. So again, the context in which these speech acts occur makes sense because they become disruptive to everyday life. They become disruptive to other people's well-being, but they become disruptive to the economy overall. So again, if someone wants to make a video or wants to have their own YouTube channel or internet account where they share their radical views, and this could also be radical left-wing views, there are many people who might dislike heterosexual religious family values, and they can share their views on the internet or in written form. They can also have debates on the internet with people who can respond to them. But when you threaten someone in their workplace, what would be obvious is that anyone who could afford to quit their job in military service would quit and they would go on with their lives. And so, what would happen to the economy? The same is true of property owners, that if I am threatened in my property, in my home, and I have enough financial capital, I can just move. If I'm threatened at my job and I could afford to quit my job, I would quit. But what would happen to the economy if every person who is middle class and who can afford to buy property and who can afford to quit their jobs just quits? So then we would have a context in which middle class property owners are going to sell their property and leave. They are not going to buy anything because they will not even work. So, what will happen to the economy? And you can think about what would happen to people who are trying to constantly sell their labor, specifically immigrants, young people, working class people who would like for middle class property owners to have the financial capital to buy things. So the law really functions because of money and the economy. And the law really protects the economy and it protects the future workforce. I'm going to skip ahead to these 5 ideas. And so in the second half of the lecture, I will just discuss these 5 ideas in general. And firstly, I'll talk about performativity in detail, and I'll try to explain performativity in ways that are uh, more clear for you. And then I'll discuss rape culture, rape law, and performativity. So, gender performativity, as I've talked about, is a term created by post-structuralist feminist philosopher Judith Butler in their 1990 book, Gender Trouble, which has subsequently been used in a variety of academic fields that describes how individuals participate in social constructions of gender. Is there a way to link the question of the materiality of the body to the performativity of gender? And how does the category of sex figure within such a relationship? And this is where Judith Butler's work is really philosophically interesting if we think about the relationship between the materiality of the body and language. So, when I was born, if the doctor said it's a girl and I was told that I was a girl, has this shaped the materiality of my body? We can think about things like fitness eating, walking? Have I learned to take up a certain amount of space in the world because of my gender identity? Speech, um, the way in which I speak English. Have I learned to speak softly? Um, the materiality of gender can also be about money. So, have I learned to accept that I will make less money um, because of my gender identity? And that is an interesting question to consider and perhaps to critique. Consider first that sexual difference is often invoked as an issue of material differences. Sexual difference, however, is never simply a function of material differences which are not in some way both marked and formed by discursive practices. So, if it were not for the existence of the gender binary, male or female, would these sexual differences exist? And if we now exist in a a system of law and a society in which there are more choices than male or female. Our laws in Canada protect transgender people, non-binary people. Our laws protect people who question their sexuality. Uh, in the history of settler colonialism, two-spirit people have always existed before colonial contact. So if this linguistic universe exists, these terms exist, then will they change how material sexual practices, how our bodies uh, take shape and space and are part of certain relationships? And I believe the answer is yes. So we may believe that our subjectivity is the source of our actions, but Butler contends that our sense of independent, self-willed subjectivity is really a retroactive construction that comes about only through the enactment of social conventions. Gender cannot be understood as a role, which either expresses or disguises an interior self, whether that self is conceived as sexed or not. As performance, which is performative, gender is an act, but broadly construed, which constructs the social fiction of its own psychological interiority. So, gender is not something that we just choose to act upon. I mean, it's not as though we, from birth, just choose to perform under signs. From the time that someone is born, they are often ascribed a certain gender identity and they're encouraged to behave in certain ways, and they are disciplined when they try to transgress gender. It is even about medicine itself, the ways that people eat, their weight, their voice is all really construed of as being normative through a certain gender binary. So, rape culture is interesting then to consider in relation to gender performativity. Does gender identity and do gender roles normalize rape and rape culture? Andrea Dworkin's writing discussed the ways that a gender doxa exists that normalizes rape. So, applied to rape, these beliefs about gender include both common sense understandings of how and under what circumstances rape occurs, and gendered beliefs about how women and men should and do behave. Hegemonic beliefs in this area are often referred to by feminists as, quote, rape myths, because they often bear little direct attention to the realities of rape. For instances, there is a strong cultural belief that rapes are generally committed by violent strangers, whereas in reality, most sexual assaults occur between partners, acquaintances, and family members. So these gendered norms in which women are subject to the authority of men as men in their families, fathers, brothers, the authority of men in a heterosexual relationship, the authority of men in the workplace can normalize rape culture. In order to refuse to consider rape as a crime of grievous bodily injury and as a hate crime, rapes are written of as unfounded and difficult to prove by the police. The statistics, therefore, do not correspond to the lived experiences of women, non-binary, and transgender people who often report high levels of rape, sexual assault, and sexual harassment in qualitative interviews. So, heterosexism refers to the process of discriminating against those who are not heterosexual. And heteronormativity refers to the normalization of heterosexuality and the refusal to understand or acknowledge or respect the existence of queer people. Um, Gay, lesbian, bisexual, transgender, intersex, asexual, two-spirit people and those who question their sexuality. And so rape narratives are often understood through this paradigm of heteronormativity, and heterosexist narratives about rape often normalize rape as something that exists on a continuum of heterosexual desire. Anecdotal evidence, narratives, and dramatizations of routine sexual violence do not match with low rape statistics in major cities in the global north. Numbers are falsified by misogyny and the constant re-victimization of rape survivors. As Young further writes, the widespread police practice of underreporting rapes also creates significant moral and policy problems. Police often aggressively interrogate and harass rape victims, pressing them to recant their allegations. In other cases, police assure victims that they are busy working on their cases when no actual investigation occurs because the complaint is already labeled unfounded. That police re-victimize by harassing or lying to rape victims is unconscionable. So rapes are often undercounted, and I would argue that there is a direct correlation between the undercounting of rape and the refusal to interrogate heterosexism, heteronormativity, and the gender binary. When you are a serial rapist, writes this author, you might be ignored by the police in order to give the illusion of safety and freedom in an expensive place. When the police refuse to take rape seriously, the absence of rape statistics can cause one to believe that they have solved problems by ignoring problems, that American exceptionalism and dreams of Western meritocracy are statistical truths rather than anomalies. As Young further writes, undercounting results in police failing to fully investigate rape complaints, leaving serial rapists who one study indicates commit an estimated 91% to 95% of all rapes, free to rape, and sometimes murder more victims. And I would argue that we've discussed this in the first lecture about the murder of Cindy Gladue. In a court of law, after Bradley Barton murdered Cindy Gladue, Gladue was referred to as, quote, a native prostitute and, quote, a native sex worker or, quote, a native girl over 50 times. Bradley Barton was not referred to as a white man. And so Bradley Barton was not referred to also as a white man who tried to purchase the services of a sex worker. Bradley Barton was not referred to as a white settler man. Bradley Barton was not referred to as a rapist or a murderer. Cindy Gladue was, quote, a native prostitute and, quote, a native girl. So this kind of refusal to hold rapists accountable is also about intersectionality, which we'll discuss next week. And intersectionality refers to the intersections of classism, racism, sexism, heterosexism, settler colonialism that all discriminate against a person like Cindy Gladue. And so Cindy Gladue is not thought of as a victim of Bradley Barton. Cindy Gladue was somehow thought of as an aggressor because she was a Cree person. And so Gladue then is uh, the kind of refusal to think of Bradley Barton as a rapist is really about gender performativity and the ways that performatives of gender and race and class and settler colonialism all intersect to make Cindy Gladue so vulnerable that Cindy Gladue is dead and dead at the age of 38 years old after being knifed by Bradley Barton in an Edmonton motel room and bleeding to death in an Edmonton motel room at the age of 38 years old. So the ways that performatives work is to uphold certain norms and certain hierarchies. So the gender binary of male-female is not an equal binary. Men are thought to be stronger, more intelligent, have more power in society. Men are thought to have the power to tell women what to do. Men can choose women to have sex with. Men can choose which women they find attractive. And women are often thought to be passive actors. The racial hierarchy that is held in place of white settlers as opposed to Cree people is not an equal binary. And so when we uphold these norms, we uphold the power of naming, and we can name, and Cindy Gladue could then be named as, quote, a native girl, a native prostitute over 50 times in a court of law, and Bradley Barton could not be named as a white man. However, protest movements do exist, and the entirety of the queer, transgender, two-spirit feminist movement does exist in Canada. And after many, many years of protests, letter writing, petitions, Bradley Barton was finally found guilty by the Supreme Court of Canada. The words wound seems incontestably true, and that hateful, racist, misogynist, homophobic speech should be vehemently countered seems incontrovertibly right. But does understanding from where speech derives its power to wound alter our conception of what it might mean to counter that wounding power? Do we accept the notion that injurious speech is attributable to a single subject and act? If we accept the juridical constraint on thought, the grammatical requirements of accountability as a point of departure, what is lost from the political analysis of injury when the discourse of politics becomes fully reduced to a juridical requirements. Indeed, when political discourse is fully collapsed into juridical discourse, the meaning of political opposition runs the risk of being reduced to the act of prosecution. So if we think about the case of Bradley Barton, who murdered Cindy Gladue, these terms, quote, native girl, quote, native prostitute, and the refusal to name Bradley Barton as a white settler man, as a sexist and racist man, as a murderer, as a rapist, is about a history of a community of speakers. And it is not the law alone that could change this. And this is why the Supreme Court of Canada was really clear in the precedent of Bradley Barton that when people in Canada murder vulnerable persons, and specifically Indigenous women and girls, the judge in all cases must publicly denounce and deter further crimes against Indigenous women and girls. And this public act of denunciation and deterrence must affect the media, it must affect the general public. So we as Canadians must be made aware of these acts of violence, and we must deter and denounce these acts of harm. And this is because our community of speakers is bound to this history of settler colonialism. So according to Cameron, the crucial aspect of language is meaning. And the point of non-sexist language is not to change the forms of words for the sake of it, but to change the repertoire of meanings a language conveys. Judges in their decisions need to take into consideration how gender norms are reenacted in the use of terms such as such as sexual intercourse, consent, resistance, innocence, and guilt, and become more alert to these terms, rendering examinable, accessible, and negotiable the human rights, dignity, and humanity of women as sexual subjects. Responsibility for the crime should be attributable to the rapist and never to the victim, and rape should always be understood as a crime of violence, the encroachment of human rights, humiliation, and inhumane treatment. So, what many scholars of gendered or queer and feminist jurisprudence argue is that these linguistic categories cannot determine bodily harm. So the fact that you were called a name in history does not mean that you can experience bodily harm and violence. It does not mean that you do not have the right to say no to sexual intercourse, or you do not have the right to flee sexual violence, or you can't divorce. I mean, the Canadian laws are quite clear that whatever name you have been marked by in history does not determine your legal rights as a person who cannot be raped or murdered. So I will play this clip of Dean Spade, who is a freedom scholar, whose work touches on many of these issues. And particularly, Spade's work has looked at transgender rights and has also looked at the law and the limits of the law. All right, just bear with me a second. If you're interested in transgender rights and theory, you might want to look at Dean Spade's book called Normal Life, which is an interesting discussion about transgender rights. And Spade writes about the law in detail and the limits of the law and the possibilities of the law in the lives of trans people. For some reason I can't find these clips. Hope they haven't been. Okay, I'll play this clip instead. It's not as recent. Mhm. Okay. Hope you're enjoying the class thus far.
So yeah, first I just wanted to say thanks. It's really exciting to be here, and I'm really honored to be part of a conversation with the other folks who are going to be in this, who I can't see right now, but who I trust are in front of you. Who are all activists and scholars who I really admire and am inspired by, so I feel really lucky. And I also just want to say, obviously, I'm coming to this work from the US, so that's like my frame. And there's some overlap, obviously, with Canadian conditions and politics and histories, but there's also a lot of divergence. So I hope it'll be useful, but it's my sort of framework. And I'm going to also be reading because I'm trying to be really concise so that we can stick to our schedule. So I apologize for reading. And when I was invited to speak at this event, I was asked to be part of a series that I guess is about critical masculinities. And so what I wanted to think about was how like really highly gendered roles in our very militaristic, settler, white supremacist societies, like spouse, soldier, police officer, have come to stand in a really complicated way as symbols right now of sexual and gender liberation in some contexts. And how weird that is, especially given that many feminist and queer movements have sought to eliminate the existence of those roles. So I wanted to try to spend these few minutes just talking and thinking about that. Okay, so I think in particular these conversations about that dynamic that I just named are servicing in important ways right now because of the role that legal equality for gay and lesbian people, and in some instances, but not usually trans people, is playing in global discourses about human rights. Increasingly, the degree to which countries have adopted certain high-profile lesbian and gay-related law reforms, specifically granting marriage recognition and access to military service to gays and lesbians, is framed as central to a country's reputation regarding respect for human rights. In recent years, the US and Israel have put significant resources into framing countries with certain lesbian and gay rights in place as modern, while framing countries that don't have those in place, particularly framing Arab and African countries, as backward and undemocratic. And this strategy of using lesbian and gay rights, particularly marriage and military participation, as a marker of being a human rights respecting country, and particularly doing so in the face of charges of ongoing significant human rights violations, has been called pinkwashing. Maybe that's a term that a lot of people have heard. In the US context, Hillary Clinton's 2011 speech regarding gay rights or human rights, along with the prevalence of references to same-sex marriage and gay rights at the 2012 Democratic National Convention, are examples of American washing. Clinton's advances a relatively new logic in U.S. imperialism, that the U.S., regardless of failures to protect queer and trans people from state violence here in the U.S., where I am, not you, will now use gay rights as a measure of countries it seeks to intervene on. Basically, like, we're going to call countries homophobic, and that'll give us a good excuse to bomb them or show up there and do weird military stuff. Clinton uses lesbian and gay rights to bolster the notion that the U.S. is the world's policing arm, forcing democracy and equality globally on purportedly backward and cruel governments. Gay rights.
So I'll stop it there. I'll try to find this clip, which is of Freedom Scholars. I don't know, I just prefer it, but that was a good clip too, though. I like Dean Spade's work, and I would encourage you to read Spade's work, which, like the text Normal Life, it's a great book about transgender rights. But we can return then to Butler and this question of language. So if under the guise of protecting queer people, certain countries or even entire religious groups of people are deemed to be homophobic, then is this also a question of language? So, for example, if a global North country deems a global South country to be sexist or heterosexist or homophobic, do they then have the right to intervene, or do they have the right to try to legislate against specific groups of people, specific religious minorities? And is this really just a question of language? So if we return to the trial of Bradley Barton, who was acquitted in the first trial, in which Cindy Gladue, whom he murdered, was referred to as, quote, a native prostitute and, quote, quote, a native girl, and Bradley Barton was not referred to as a white man, then we can ask about the kind of what language really teaches us is about hypocrisy. And hypocrisy is often easy to understand in linguistic terms, that when Bradley Barton, a white man, was accused of murdering this Cree person, Bradley Barton could not be named as a white man. But in other contexts, say if someone is from an Arab or African country, then their religious or cultural practices could be named as suspicious. Economic justice and economic injustice is, I think, at the root of all of these problems or all of these issues regarding what others do and what others say and what people and the kind of sexual practices of others, that Bradley Barton, as a white man, cannot be made to be suspicious. And the majority of money that is earned in Canada, the richest people in Canada, people who own the most property in Canada, are white men, and they are white English speaking men. And so making a group seem suspicious or strange who is rich is often not what the media does, and it's not what the law does. The law often, and institutional violence and systemic discrimination often works by waiting for minorities to make mistakes. And when these minorities, women, queer people, trans people, people of color, immigrants, make these supposed mistakes, they are called injurious names. They're subject to discipline, policing, scrutiny. When white men knife someone in a motel room and that person bleeds to death, they are not referred to as white men. They are victims of, quote, a native girl or, quote, a native prostitute, as is the case in the Ontario courts when Bradley Barton was acquitted and there had to be mass protest, years of lobby groups, demonstrations for this one person, Bradley Barton, to go to jail. And it took years and it took a lot of taxpayers' money for him to finally be convicted in the Supreme Court of Canada. He could still, of course, try to appeal, and he could appeal as a, quote, white man. So Butler is interested then in consequences for injurious speech. So what is the consequence in a court of law for referring to a Cree person who bled to death and who was knifed and bled to death and who was murdered and died of knife wounds and knife wounds in their vagina? So what is the consequence of referring to this person, Cindy Gladue, as, quote, a native girl or native prostitute? Are there any? In order to establish injurious consequence within the domain of accountability, is it necessary not only to install a subject, but also to establish the singularity and discreteness of the act itself, as well as the efficacy of the act to produce injury? If the injury can be traced to a specifiable act, it qualifies as an object of prosecution. It can be brought to court and held accountable. But this tracing of the injury to the act of the subject and this privileging of the juridical domain as the site to negotiate social injury does this not unwittingly stall the analysis of how precisely discourse produces injury by taking the subject and its spoken deed as the proper place of departure? So the law only really focuses on acts like the rape and murder of Cindy Gladue, the knife wound in the victim's vagina. But the naming of Cindy Gladue as the, quote, native girl, quote, native prostitute over 50 times, and the refusal to use the term Cree person is obviously where the injury begins. And it is this domain in which the law cannot legislate against. The refusal to understand the Cree people as a nation, as the Cree nation, and the refusal to see Cindy Gladue as someone who has title to land, as a Cree person, is where the injury begins. And this kind of I mean, the insult is what causes the injury. People often use this term, will add, you've added insult to injury. No, in the language of, if we look at performativity, it is the insult to the Cree people and the Cree nation that has caused this person to die and then never be referred to as a Cree person who is part of a Cree nation in a court of law. This is also what has caused mass protests at Wet'suwet'en in British Columbia, and this will cause mass protests again and again. So Corey Rayburn is interested in performance in courts of law. And if you're interested in thinking about the law and law school, or if you're interested in writing about legal cases, you can think about how gender is performed in a court of law. And there are many cases and instances where the clothing that a rape victim wore, the consumption of alcohol of a rape victim, the gender identity, even the age, the body size, the prior sexual history of a rape victim is actually what is put on trial rather than the criminal who raped someone. So Rayburn writes, while every trial has elements of theater, rape, and sexual assault cases are unique because they emphasize the gender performances of the accuser and the accused. Complainants who testify are not just recounting the events of the alleged rape. They are also defining the essential parts of their gender roles for the jury. Every statement, mannerism, action, and emotion of the accuser on the witness stand relays information about her gender to the jury. If the jurors deem a performance too emotional, they may assume the accuser is stereotypically hysterical and unreliable. If, however, she appears cold and calculating, the jury may believe she is a gold digger, using the criminal trial as a prequel to a lucrative civil suit. So if we turn to Judith Butler and the gender binary, what I think we should all always keep in mind is that binaries are not equal. The binary between black and white is not equal. George Floyd, citizen of the United States of America, was murdered by the US police. And in a court of law, he was referred to as having, quote, counterfeit currency. So just like the posthumous trial of Cindy Gladue, a, quote, native prostitute, quote, native girl, who was referred to in these terms in the Ontario court over 50 times, George Floyd was referred to as someone with, quote, counterfeit currency. The history of slavery and the counterfeit currency of slavery was not made reference to. So these people are put on trial after they die. And if we think about binaries, then white and black is not an equal binary. Male and female is not an equal binary. So if you were on the kind of lower end of the binary, if you were seen to be lesser than, then what the courts are always kind of trying to do is to demonstrate that you are lesser than, and you are lesser than the person you accuse of committing a crime against you. And because you are lesser than, you can always be made to be lesser than, and then your legal claims are lesser than theirs, and your legal rights are lesser than this person who has more power than you in this existent framework. And this is why challenging these binaries is important. And it is important societally over generations, so that people will not assume that someone does not have the same legal rights as another person. So rape law and performativity intersect at the intersection of legal definitions of consent, the social construction of gender, and the theatrical nature of courtroom proceedings. Performativity, the idea that gender and identity are created through repeated actions rather than innate traits, critiques how rape laws often rely on rigid, stereotype performances of victimhood and consent. So the perfect victim narrative is something that feminist scholars and scholars of queer and feminist jurisprudence often discuss. The perfect victim is often white, heterosexual, able-bodied, married, and is often attacked by someone who has lesser class or racial privilege than her. If someone is not a, quote, perfect victim, then the burden of performance in the court is often placed on the victim rather than the accuser. And this makes it very difficult for victims to achieve justice. But this idea of perfect victimhood really all rests upon binary constructions of identity. So the idea being that this white-black binary exists in our minds, and we utter these words or we make these judgments because we are part of a history of a community of speakers. And our history is not an innocent history. It is a history of settler colonialism. It is a history of slavery, and it is a history of transphobia, lesbophobia, and heterosexism. So the more that our laws in Canada work to redress these historical imbalances, our language should change and our judgments should change. And Bradley Barton was found guilty by the Supreme Court of Canada. And in the legal precedent that the Barton case sets, in the future, any person who murders a vulnerable person, and specifically an Indigenous woman or girl, will set a precedent, and the judge in the case must not only prosecute this individual person, they must deter and denounce this violence in Turtle Island, also referred to as Canada. So language does not just exist in courts of law, and it does not just exist in institutions or in official ledgers. Counterculture and protest movements challenge language, and there have been many successful anti-rape movements throughout the world in which protesters talk back to the states and refuse to be subject to these violent interpolations of state power, which serve to script their lives within gendered and racial and class-based binaries in which their victimization is not taken seriously. And a good example is this movement, A Rapist in Your Path, which was a protest movement in Chile. And I hope the clip works. I will try my best to do a better job in the future of making sure the clips are organized in a timely manner. Okay, this one. So this is a protest movement that took place in Chile, and it is called A Rapist in Your Path. So these protesters then implicate the state, and obviously Chile is one example, but as we've talked about in the trial of Bradley Barton, the feminists and the two-spirit queer transgender feminist movements in Canada have also significantly have done a lot of significant activism and protest, particularly after cases like the murder of Cindy Gladue. So these protest movements are ongoing, and they serve to try to implicate the state in these processes whereby gender binaries and racial hierarchies and class-based hierarchies turn criminals into victims and victims into criminals. Finally, I'll finish by discussing hate speech. So in the article regarding injurious speech acts and cross-burning, Judith Butler discusses this problem of hate speech. So hate speech on the one hand is, yes, injurious, and it does damage to others, but hate speech is not just about one individual person who has made up their own language. Hate speech makes reference to an entire community of speakers. So when Cindy Gladue was referred to as, quote, a native girl and, quote, a native prostitute, and was not referred to as a Cree person, whoever said this was an individual person, but their words and what they meant in the context of Canada, in the context of the murder of this person, Cindy Gladue, makes sense to us if we understand a community of speakers and a history of settler colonialism and a history of damaging stereotypes and representations of Indigenous women as being threatening and rather than threatened by Canadian society. Defenders of hate speech prosecution have had to shift the analysis to acknowledge that agents other than governments and branches of governments wield the power to injure through words. Indeed, an analogy is set up between state action and citizen action, such that both kind of actions are understood to have the power to deny rights and liberties protected by the Equal Protection Clause of the Constitution. Consequently, one obstacle that proponents of legislation against hate speech have discovered is that the state action doctrine qualifies recourse to the Equal Protection Clause in such instances, presuming as it does that only governments can be the agents of harmful treatment that results in a deprivation of rights and liberties. If the power of a one to effect such an injury through the wielding of the injurious name, or is it a power accrued through time which is concealed at the moment that a single subject utters its injurious terms, does the one who speaks the term cite the term, thereby establishing his or herself as the author, while at the same time establishing the derivative status of that authorship? If performativity requires a power to effect or enact what one names, then who will be the one with such a power? So what interests Butler then is this question about responsibility. Are we responsible for our individual acts of speech? Yes, and in the eyes of the law, we can be held responsible. But when we try to make arguments, for example, when a lawyer tried to defend Bradley Barton in the Ontario courts, the lawyer knew that they could draw on these terms, quote, native girl, quote, native prostitute, to try to exonerate Bradley Barton. And it is only because of a history of negative media representations, a history of land theft, a history of settler colonialism, a history of the rape and murder and sterilization of Indigenous women and girls, and a history of discrimination against Indigenous people that we all participate in as settlers, that these terms have force. So I will finish then with this quote by Judith Butler. To operate within the matrix of power is not the same as to replicate uncritically relations of domination. So we all operate within this matrix of power to a certain extent. We speak in the English and French language as official languages in Canada, but this is not the same as to replicate uncritically relations of domination. So our laws are quite clear, and there's obviously a difference between making a mistake or trying to make an argument, and also willful harm and neglect of others, and willfully trying to do damage to others because uh, of one's dislike or hatred of others. And Canadian law is quite clear in protecting protected persons, including persons of different gender identity and gender self-expression, from harm and from significant harm. So I hope you have enjoyed the lecture this week, and I apologize for technical technical difficulties, sorry, with not only my own speech, but with video clips. And I will make sure that it's smooth next time. And I hope you're enjoying the class. And I've also posted a short video online about assignments. Thank you. Goodbye.